That I would now ask the attorneys in the matter of 124601, State of Kansas versus Kimberley Younger, to please come forward.
May it please the court, Clayton J. Perkins of the Capitol Appellate Defender Office, appearing on behalf of the defendant appellant Kimberley Younger, and joined today at council table by Caroline Zuschek and Catherine Stevenson, also of the Capitol Appellate Defender Office. I would request 2 minutes for rebuttal, if I may.
2 minutes is granted.
It is undisputed in this case that Kimberley Younger was convicted of capital murder without having killed anyone. And her conviction rests upon the troubling foundation of the credibility of co-defendants, including the actual killers that received reduced or lesser convictions and had incentives to place culpability on Miss Younger, and whose testimony was propped up by numerous constitutional and legal errors. Of those errors, I plan to spend the bulk of my time today on issue 1, the confrontation issue, and possibly issue 2, if time permits, and submit the remaining issues on the brief. That I turn to issue 1 in the brief, which appears to be the only instance, at least to have made its way to an appellate courts in Kansas during the pandemic, of a witness at a jury trial being allowed to testify remotely via Zoom over the accused's assertion of the fundamental right to face-to-face confrontation.
Is it your notion that this simply can never happen and that no witness can appear by Zoom or by remote circumstances, and so therefore the conviction? Or are we into the details of the judge's consideration of the various factors that led the judge to decide that the person could testify remotely? Those are two different things. And I just want to narrow it down if we can.
Those are two different things. I think that this court should not expand the Maryland v. Craig rule in this case to any of those scenarios. I think if we get into a Maryland v. Craig type of analysis, this record does not support that. But I actually think initially it's in the framework of this, I think there's further problems that means this court might not even really find it necessary to reach the ultimate questions of whether or not this could ever happen in a different hypothetical scenario. And I think the part 1 of the framework that this court has to ask is, of course, whether or not the 6th Amendment and Section 10 of the Bill of Rights apply. And then following that, there are the subsequent questions of, are there any exceptions to those constitutional protections? And if so, and then harmlessness. And back to the first point, which is, do the 6th Amendment's right to confrontation and Kansas's express right to meet witnesses face-to-face apply? That's unquestionably, I think the answer is yes. And I think the first issue in this case, and where this court may find the initial error, is just in the fact that the constitutional rights apply. And putting that in the framework of this court's administrative order that came up in this case, the first line of that administrative order when it talked about remote testimony was that it was subject to constitutional limitations. And the problem initially comes in this case that when the state asked for this witness to appear remotely, they framed it under that administrative order, but did not address the subject to constitutional limitations. The district court's ruling was applying the presumptive good cause standard that is discussed later in that administrative order to allow remote testimony, which is a fair and good standard in light of the pandemic and when that is an allowable process. But in this case, the right to confrontation protected in our state and federal constitutions applied. And we do not have the district court's application of a Maryland v. Craig based, say, necessity test or any of the various formulations happening in this case.
Well, explain to me how that is correct. Didn't the district court go through the Maryland v. Craig factors and find that it was met?
We have applications of we have argued applications of those factors to the court's ruling that they did make, but the district court made a good cause ruling, and at the hearing on this, the state asked the court to apply the presumptive good cause standard. So I don't think we actually have a court specifically addressing these factors or making the specific findings to begin with. And then I think turning to the second question, are there exceptions to the constitutional protections? And if so, what? If we get to that question, I don't think the findings that existed here were, one, I don't think the Maryland v. Craig standard should be expanded. And two, they did not meet this test in this case.
Counsel, are those both then questions of law? There's no fact finding necessarily, or are you saying that there's a mixed standard?
Correct. I think we are talking about wholly legal questions here. Did the district court apply the correct legal standard? What was the correct legal standard, which is an undecided question.
And so if the district court makes findings to suggest under the administrative order of our court that the COVID policy is furthered in this instance, then it's a question of whether that policy is weighty enough then to justify an exception under the Supreme Court precedent. Is that the correct way to frame the issue?
Yes, is that policy in and of itself to meet a Maryland v. Craig style test? And of course, I want to mention that, of course, the status of Maryland v. Craig in that case, this is a application of a pre-Crawford opinion, post-Crawford. And of course, Maryland v. Craig applied the Ohio v. Roberts reasonableness standards that were expressly overruled in Crawford. So I think for that purpose, and as we cited the Missouri Supreme Court in our reply brief, there is good reason to limit Maryland v. Craig to the express facts that it applied to, and to not expand that, particularly in this sort of instance, which would be a potentially broad extension of that right. Then in the hypothetical of addressing what Maryland v. Craig would look like if it were expanded, I think the first thing to remember about Maryland v. Craig is that it was applying a very specific finding, and that was a specific finding, one based on the youth of the witness, but also specifically tied to the harm that would occur by testifying in person in front of the defendant. It was very specifically not a test that's addressing the general harm of appearing in the courtroom, which is at most what we would be talking about in this case with these findings.
Why would that matter to the defendant's rights? I mean, if it's okay, override the defendant's rights because of some notion that the testifying victim is in the courtroom and that's very stressful, then it seems like there could be other circumstances that could also override the defendant's.
And I think it matters to the defendant's rights, of course, that the exceptions to our expressly protected constitutional rights are limited. And I think that's really the important point in Maryland v. Craig, is that this is a remedy that is only appropriate in instances where the only remedy to the harm is to avoid face-to-face confrontation, because it's tied to the defendant being in the room and the witness being in the room.
I'm kind of making the slippery slope argument. It seems like once you can find circumstances that override to confrontation or face-to-face confrontation, then might be able to find we might want to limit it to serious circumstances, but still an override.
And again, that is why I think, this court should be wary of expanding Maryland v. Craig. It is, of course, a sort of balancing based on a reasonableness analysis that has since been rejected, that is overriding constitutional rights. And indeed, as Justice Scalia said in the Coy opinion, really the core of the right to confrontation and the express protections in our state constitution to meet witnesses face to face. But moreover, the only instances where it was allowed in Maryland v. Craig are again tied to harm directly about the defendant and the witness being in the room together and meeting.
What do we do in a pandemic when, what was placed on the record, what this witness was vulnerable, threatened? Thought the court did a pretty good job of stating not only was this a spike, I think this was one of the iterations after the original COVID of the Delta strain. It was happening in Barton County. In fact, they had to delay the trial because of a couple of jurors contracted COVID. It was a real phenomena that was happening, that people were threatened, witnesses were threatened. This particular witness put on the record, and the judge found it to be credible, he was vulnerable to COVID. All of that occurred. There's no remedy for that. You just continue the trial indefinitely. What do we do in that instance when we're confronted with a situation like this?
And I think the first thing to note is that this is not an indefinite case. And this is not, as some of the cases cited in the state's brief and early in the pandemic case, where there are questions about.
So your right to speedy trial just gets, that gets suspended. All of those things, other constitutional concerns also don't get addressed, or we deal with those.
Certainly, I think it is a question first for the state in balancing the witness, which is a witness that they were calling, in balancing the impact on a defendant's Sixth Amendment right to a speedy trial versus the express rights to confront that witness. So there is a question of whether a continuance would happen. In this instance, we're of course talking about a very temporally limited frame. This is not when we didn't know when a vaccine was coming. This was a period where we had a vaccine. This witness was vaccinated. At most, they were waiting for a booster shot, which was, as we all experienced, became readily available. So this is not where we
Yeah, looking at it in retrospect, I mean, in real time, which is what we have to look at, right? I really don't see a big difference between Maryland versus Craig and what's happening here. You're trying to distinguish between a child coming in and having to confront the witness. But here, you have an elderly person who is suffering from health conditions. And yes, he's vaccinated, but it's not just being in the courtroom. And it was, there was a spike in this county, but he would have to travel on an airplane. And I don't know about you, but I wasn't traveling on an airplane during this time, even with a mask. So he would have to travel on an airplane and put himself at risk, literally putting his life at risk. Okay. And when you compare that to the child who's going to, suffer some emotional trauma by confronting the perpetrator. Okay, well, isn't this even more that, at least that child is going to live? We don't know the risk, because at that time, we didn't know whether there was, that was the Omicron variant. That's when things started, so we'd been vaccinated on the other first one, but not on the second one. I just don't really see the difference here.
And I think the first point I would make on that is, and in the fact that there's a lack of the sort of Maryland v. Craig very specific findings of necessity here. This witness was traveling on airplanes. He testified that he had traveled from Florida to New York via an airplane 2 weeks before the trial. He was in Oklahoma, having reached there by an airplane at the time of this trial. So we're not even talking about him flying to get here. That would, I assume, be a
Well,
car
that
ride.
came in afterwards, right? I mean, they didn't know where he was on the day of trial, did they? I thought that was afterward.
He testified that was where he was from at the trial.
Well, that was where he was from, but
Or
then he
wait,
flew
wait.
from New York to Oklahoma. I thought that was afterwards. I could have the facts wrong, sorry.
But that determination was made prior to trial that he would be allowed to testify via video. That
Yes, approximately.
one of the things you mentioned in your brief, that part of the problem with this, and I just want to clarify that there's potential problems with video transmission, clarity, those kinds of issues. There's no evidence in the record that that happened in this case. And in fact, you got to cross-examine the witness pretty clearly, at least from what I read.
I think there is evidence in the record of video transmission errors. There was the fact that the witness at the pretrial hearing could not actually tell whether Miss Younger was even wearing glasses or not, which is a pretty big issue in the concept of face-to-face confrontation if you can't actually see the defendant's face.
I'm talking about a trial, though. Was there any evidence of that?
I think the biggest concern there is the the witness's testimony about whether or not he had ever seen Miss Younger, which would be inconsistent with having been able to see them or see her at the pretrial hearing. So he also could not distinctly make out the people at counsel's table.
You're out of time, but I would just want to mention the Section 10 argument and comparing it to the Sixth Amendment. The difference is the face-to-face language that appears in Section 10, and I don't see anywhere in the record, at least at district court, that you developed that argument was ever developed. It was just kind of this argument that Section 10 applies in the Sixth Amendment. It's briefed and the amicus briefs it, but I don't see that being developed at district court. Is that right?
There was no distinct argument made except for, of course, the fact that this is expressly protected.
Thank you.
Would you interpret Coy versus Iowa as kind of adopting Kansas's constitution where it says the Sixth Amendment provides for face-to-face encounter between witness and accused?
Yes, I would say that's very consistent.
Okay, thanks.
And if I may have a brief moment to rise, I would turn finally to Justice Scalia's language in Coy v. Iowa, and specifically the way it addresses the impact of this type of confrontation error. And in that opinion, Justice Scalia said, an assessment of harmlessness cannot include consideration of whether the witness's testimony would have been unchanged or the jury's assessment unaltered had there been confrontation. Such an inquiry would obviously involve pure speculation. And I think that is.
So how do we do a harmless error analysis? Because isn't that the very gist of our analysis?
And I think you hold the state to its burden to prove beyond a reasonable doubt that this error did not contribute to the jury's verdict. And that cannot happen in this case. The state cannot meet that burden because as the state was in the courtroom at that time and had the ability to see the defense presentation of evidence in this case, they made the analysis that they needed Frank Zaitchik's testimony to rebut the defense presentation and to make sure the jury had that, and they cannot now remove that.
That goes to my question, which is if we're conducting a harmlessness analysis, are we supposed to assume that the witness would have testified in person or would not have testified at all?
I think the analysis is, can the state show that the outcome would have been the same without that witness's testimony?
As opposed to would have been the same had the witness been flown in or driven in and sat in the witness box.
Yeah, I believe the Coy analysis is you do not reevaluate whether the testimony would be the same.
Well, but whether it's the same is different from whether he would have testified at all, isn't it? In other words, I think Coy could be read to suggest that you take the testimony as it's recorded in a record And you presume that that testimony would have been given in person, that identical testimony.
And I think that is the part in that passage that is saying that would be speculation to assume what the testimony would be or how it would be
Well,
with face-to-face confrontation.
I
is-
feel like we're missing each other.
Okay.
I'm asking if not about the content of the testimony, but about whether it would have happened, period. In other words, had the district court ruled in your favor and said to the state, nope, can't do remote. Now, are we supposed to assume that the state would have gone ahead and forced the witness to come in person, or would the state have prosecuted the case without that witness? That's my question.
And
I think it makes a big difference here. That's why I'm asking.
I think it is assuming that or I think you have to assume or look to the record without any regard to that witness.
That's that you look to the record and without regard to the testimony, just it would be absent.
Well, now I'm second guessing myself on this one. I'm sorry, Your Honor. I think, I guess what I will say is I think the core point of Coy and that reasoning is that any answer on what this witness would or would not have testified about is speculation and not to engage in that.
Elflager?
May it please the court, Chris Elslager appearing on behalf of the state. As we've been talking about, Maryland v. Craig, the U.S. Supreme Court, excuse me, made clear that the confrontation clause is not absolute and that it must occasionally give way to considerations of public policy and necessities of the case. And I don't think there's going to be any argument that during the COVID pandemic, which was probably at least a once in a century kind of event that locked down businesses, schools, courts, et cetera, that this was a serious public health incident.
Counsel, do you think Section 10 gives way to public policy concerns?
I do. I think
On what ground?
there's no difference between Section 10 and the Sixth Amendment to the United States
They're not,
Constitution.
there's a substantive difference in its effect. I think you have to make the additional argument that there's a difference in the way we ought to apply it.
Well,
You know,
I
not to
disagree.
go outside the record, but I've heard the state argue many times that, you know, the Constitution should not be read to enable courts to create public policy exceptions. Why is there a public policy exception here?
well, the United States Supreme Court in interpreting the Sixth
I
Amendment.
know, that's why I'm
I-
asking about Section
I'm
10.
going to get there.
Okay.
Let me, they carved out, they said it has to occasionally give way to considerations of public policy and necessity. And the reason I think that the Kansas Constitution and the Sixth Amendment should be read the same, because even though the language is slightly different, they could only have meant the same thing, because back in 1887 to 89, when the Bill of Rights was written, and in 1861, I think it was, when the Kansas Constitution was written, there was only one way to confront witnesses, right? So they were addressing the same thing. There was no Zoom, there was no phones, there were no video cameras, whatever. So there was only one way to confront witnesses, that was face to face. So they mean the same thing. And so the same, I think, unless you want to, the court find some reason that it wants to read Section 10 differently than the Sixth Amendment, they have to, the same rules apply. This court has never read Section 10 to be different from the Sixth Amendment. I think I cited in the supplemental brief or my reply brief to the amicus case law to that extent.
Her concurrence in Maryland or in Coy, Justice O'Connor specifically referred to face-to-face confrontation in the context of the Sixth Amendment. Does that matter?
Well, again, we're using face-to-face and confrontation kind of interchangeably, because again, in the initial, when these documents were written, that was the only way. But when you look at Maryland v. Craig, it essentially says, in certain situations, you can have an exception to the actual physical face-to-face, as long as you meet all of the other things that the Sixth Amendment was supposed to protect, which is the witness testifies under oath, which happened here.
But
The person is subject to cross-examination, which happened here. The jury could see the witness and hear his voice, which happened here. And there's no wrong, and the other thing is there's no possibility that the person could wrongfully implicate the defendant, and which of course couldn't have happened here because all Mr. Zajac said was, I don't know her. He didn't implicate her at all, so.
But to Justice Stiegel's question, which is that Section 10 of the Kansas Constitution refers specifically to the defendant shall have face-to-face confrontation. That doesn't say that in the Sixth Amendment. But Justice O'Connor specifically referred to face-to-face confrontation in the context of the Sixth Amendment when they were interpreting the Sixth Amendment in Coy. So to Justice Stiegel's question, does Justice O'Connor's reference to face-to-face confrontation matter as far as the Kansas Constitution is concerned?
No, because I think the terms that face-to-face and confrontation in the Sixth Amendment mean the same thing. Again, when the framers of the Kansas Constitution wrote that, there was no other possible way to confront somebody. And the danger that they were protecting against wasn't somebody appearing by Zoom. They had no concept of that. They were protecting against somebody, the prosecutor coming in with a stack of written affidavits from people who weren't going to testify saying, here, this proves that the defendant did it. Or from the police detective coming in and saying, well, I talked to all the witnesses and they said the defendant did it, but those witnesses not showing up. That's what the Confrontation Clause was meant to protect against. That's what Section 10 of the Kansas Bill of Rights was.
Oh, go ahead.
I'll grant you for purpose of the question that the two mean substantively the same thing, face-to-face confrontation. What I was trying to drive at earlier is an understanding of the state's position as to why there ought to be exceptions. If the U.S. Supreme Court wants to construe the Sixth Amendment to give it exceptions, it has the constitutional authority to do that. Why should we construe Section 10 to include exceptions? There are no exceptions in the text, right?
Right, but I don't think there are any exceptions in the Sixth Amendment either, but the court using its authority to interpret the law crafted exceptions to meet the necessities.
So my question is, why should this court do the same thing?
Because you have the authority to do that.
That's not a why. I mean, yes, we have the authority. Yes, but I want to know what's your best argument.
Because as Justice Rosen pointed out, what do you do in a pandemic? I mean, the pandemic shut everything down, right?
So that should supersede the defendant's explicit right in Section 10 to have a face-to-face confrontation with his or her accusers.
In narrow circumstances. And I think what you have here is a narrow circumstance where the district court made very specific findings of fact.
Because there's just policy exceptions to constitutional rights.
Well, there has to be, or else, as Justice Rosen said, well, then we throw speedy trial out the window. We just stop the criminal justice system.
When have we ever done that?
Well, when have we had a pandemic like that before?
The speedy trial rights that were suspended were statutory rights, not constitutional rights.
But there is a constitutional speedy trial right. And if you take
Are there public policy exceptions made to that in any case?
Well, in this case, there didn't need to be, but we didn't know at the time, at the beginning of the pandemic, how long it would last. I mean, it's easy to look back with hindsight and say, oh, well.
What is the limiting principle on public policy exceptions to explicit constitutional rights?
Well, I think you have to take it a case by case basis. I think when you look at something like.
So at the end of the day, it's this court is the limiting principle.
Well, yeah, I think at some point you have to take the judgment of the seven of you and look at the circumstances that we were facing. You wouldn't do this in an ordinary, if there was no pandemic. If this that wouldn't happen. It's because there was a pandemic that was so severe that it shut down everything. I mean, we would have in 2020, 2021, we would have been having this discussion over Zoom, right? Just like what happened here, which was coming at the end of the pandemic. I mean, they had a live trial and they had one witness who, as the district court found, was especially vulnerable. And there was a high transmission rate in Barton County, made all the findings that I think would meet the Maryland v. Craig standard.
Counsel, I think what Justice Stiegel is saying is if we open the door to this limited, as you said, public policy exception, then what else is going to be out there? So we can think of 100 different hypotheticals of individuals that for public policy reasons don't don't want to come and testify in person and that there are public policy reasons supporting that.
Well, and of course, the slippery slope argument can be made with just almost any kind of exception, right? So I think you have to limit it. I mean, certainly you would say limited to the facts of a pandemic, of the level of COVID-19. There's
Okay, so
certainly
let's
ways that you
take
can
that-
limit it.
Let's take that a step further. This is kind of an unique situation with this witness, but let's take a rape case where, can the victim, it's a 30-year-old woman or man for that matter. Would we make the same decision there? Because of COVID? Where it's, this is different because this is kind of an ancillary witness. And you're really doing it to impeach her testimony. But if the main primary victim that is, the complaining witness, do we do the same thing there?
Well, I don't know, but facts matter. As somebody asked earlier, if this was purely a question of law, I don't think it is. I think it's a mixed question of fact and law.
Saying you said earlier, let's make an exception for COVID.
Well,
Because it's a once in a century.
right. And still within that, I'm not saying a blanket rule for COVID. Within that, you do what the district court here did. I've cited in the brief, there's some courts that have said, well, COVID's enough, right? But most of the courts that looked at it said, well, COVID is enough to get over the threshold, but the court still needs to make specific findings that is a necessity of this particular case. And I think that was made in here. And that's the rule I would suggest that you adopt, that you have to have some kind of event that is so.
But if the particular facts of the case need to be considered, do we consider the fact that 2 weeks before trial, he got on an airplane and traveled to New York? And then even after that, where they, had the discussion about whether he was going to come or not, he says, I can't come. And then he got on an airplane and flew to Oklahoma in the 2 weeks between that conference and trial. Are those facts we should take into account as well?
I think you take into account the facts that were before the district court and Mr.
Well, that was
Zajac,
before the district court.
when it made the decision, but yeah, I think, yeah, you can consider that, but I think, Mr. Zajac kind of explained away why he was particularly concerned for going to Barton County. It had a lot to do with the high transmission rate in Barton County. And the fact that when he was out doing his carnival stuff, he was outside, he's not in an enclosed room with a bunch of strangers. Now, of course, an airplane is that way. I don't recall what in the record when he flew or whatever, or where, if he was coming from a place that had a low risk to a low risk, et cetera. But, the district judge considered that and I think made a reasoned decision. I think the facts do matter. And I think then when you look at, the ultimate, what's the prejudice to the defendant? I mean, again, he testified under oath. He was cross-examined.
Well, we'll go into that. I think, again, Justice Stiegel had a very good point. When we're reviewing harmlessness, do we review it? Well, it's your burden, of course, if we got that far. And do we see what the prejudice is or the harm is if he would have testified in person, or do we look at the harm if he wouldn't have testified at all?
That is a very good question, and I don't know the answer to that. I think in my brief, I went back and just looked at it. I think I did both in the brief.
Okay.
Which I know doesn't help you, but
Given that it's the state's burden,
Yeah.
would it make sense to require the state to make a proffer that the state would have required the witness to come in at the time the court was making the ruling on the remote testimony? In other words, you're smart lawyers, you're looking down the road, this is going to get appealed. I want to make sure that we have a factual record that we would have put this guy on, period.
Well, certainly that wasn't done here. I think to some extent the defense has a burden to challenge.
Well, the defense did challenge. I mean, they
to
asserted
make
their
the state,
rights.
well,
And,
yeah, I don't know.
when you get to harmlessness, it is the state's burden.
I think, either way is speculation. We do know what his
Well, that's,
testimony was.
if there was a proffer in the
Yeah,
record, that's
yeah.
what gets us past speculation.
Right. Well, certainly wasn't done here. So I can't, all I can say is we do have his testimony in the record and there's no reason to think that it would have been any different in person.
I agree with that. The only thing that we don't know is whether the state would have gone
Yeah.
through the trouble. to
I
make him
think
come.
though, the second half of my harmless error argument in the brief was basically, look, even without his testimony, she still would have been convicted because he wasn't part of the state's case in chief. She was convicted on the testimony of essentially her co-defendants, her co-conspirators who assisted her in the murder. That's what really convicted her, that, and then her statements to the police, the fact that she had the murder weapon. I mean, there's so much, there's a mountain of evidence. All Mr. Zajac did was come in and say, I don't know her. And I mean, yeah, that torpedoed her story, although her story was, the whole carnival mafia thing is rather implausible to begin with. But if you take Mr. Zajac out, there was the other witness, Vinny, who testified in person, and he denied her story. So I think if you want to go down the road of just removing Zajac's testimony completely, it's still harmless. She still would have been convicted. I mean, the evidence was pretty overwhelming of what her role was in the murders.
Was he subpoenaed? How did you tag him? Because he was out of state, right? I wonder how you tagged him.
I don't know that. I'd have to go back and look in the record. It wasn't an issue in the briefing, so I don't recall. I would think there was a subpoena, but I don't know. I just don't know.
Well, you can't really make a proffer though, can you? I mean, that would also be
Yeah.
speculative. I mean, Zajac could say, throw me in jail. I'm not coming.
Yeah. To be honest with you, I'm thinking about the proffer question as I stand here, because I had not until he asked it, I hadn't considered it. So it would be challenging to do that.
So don't we have to assume he wouldn't have testified at all?
I don't know, because the error is that he was just not testifying live in person, or the alleged error is that he wasn't in person. In my mind, I think, well, what difference would it make whether he was in person or on Zoom? He would have testified the same. But I mean, I also get what you're saying, which is why honestly, the easy road is that we don't go there. Right there, that you find that consistent with the Maryland v. Craig, that the district court's decision here was constitutionally acceptable and there was no error. If you get to harmless error, I think the easy road, the other easy road is to remove his testimony and look at the evidence. And I feel absolutely 100% confident that even without Zajac's testimony, Ms. Younger would have been convicted regardless. And I don't think there's any possibility that she would not have been convicted, especially when you factor in the other rebuttal witness who basically denied her rather far-fetched story about the whole carnival mafia thing. So I think regardless of how you look at it, this case, either you find no error, you find it was harmless, and you probably don't need to delve in to that particular question on the harmless error analysis. I think you could just assume, for the sake of argument, that you take that testimony away, she would still be convicted. I'm not 100% sure that you would do that, though. I mean, again, in my mind, I think, well, what's the difference whether he was there in person or on a TV screen? His testimony.
And let
was the
me
same.
again, that's your argument, and you make a pretty good argument about that. But where's again, what I'm having trouble finding is if there's an exception utilized, how do we do that? Because basically, you could argue that with any state witness that their testimony was clear. You could confront the witness. It's just as good as in-person testimony. Essentially, is what you're arguing about Zajac. How do we address the exception that you want us to address? Just Maryland v. Craig, necessity, and kind of, it's difficult to pinpoint, because essentially what you're saying, there's no difference.
Yeah, and I think
In his testimony, but that would be true in any witness's testimony.
right, and I think, but it has to be within the context, the framework of Maryland v. Craig. There has to be some kind of public policy necessity, some kind of necessity that requires the defendant or the witness to testify remotely. And I think we certainly have that here with the COVID pandemic and the specific findings regarding his risk and the high transmission rate in Barton County.
So do you adopt O'Connor's concurrence in court? She said the face-to-face confrontation requirement is not absolute, does not, of course, mean it may easily be dispensed with. As we suggested, our precedents confirm the defendant's right to confront accusatory witnesses may be satisfied absent a physical face-to-face confrontation at trial, only where denial of such confrontation is necessary to further an important public policy and only where the reliability of the testimony is otherwise assured. Is that your position then?
Yes, yes, that's it. And I think that when you look at the four factors that they talk about to ensure reliability, which is the under oath, the ability for cross-examination, the ability for the jury to see and hear the witness and the no possibility of an improper implication. I think that's all included in that. It's included in Maryland v. Craig, and that was addressed here by the district court.
But counsel, I thought I understood your argument earlier to be that face-to-face isn't ambiguous because in 1859, when the framers drafted, the Wyandotte Convention, our Kansas Constitution, there was only one way to confront. So face-to-face unambiguously means physical presence under Section 10. Or did I miss your argument? Are you suggesting there's now ambiguity?
What I'm saying is that what I said was, or what I was trying to convey is that Section 10 means nothing different than the Sixth Amendment, and that how the U.S. Supreme Court has interpreted and applied the Sixth Amendment should apply to Section 10. That's obviously back then they didn't have any of these other considerations, right? Face to face was the only way to do it. But now we have technology that allows us to talk face to face, but over the internet. To me, there's no difference, but I mean, obviously that's just my opinion of it. But I think if you are going to dispense with the actual physical in-person testimony, like was happened in Maryland v. Craig, I think that should apply as well to the Section 10 of the Kansas Bill of Rights. As long as you meet those requirements, you have a true public necessity and true necessity for the case, specific findings are made, and you meet those reliability factors, there should be no constitutional error under either the Kansas Constitution or the Sixth Amendment.
So the vehicle to do that is, from what I'm hearing you say, is face-to-face can mean other than just physically face-to-face under Section 10?
Well, you could, yes, or an exception to, I mean, I the same way, again, I think Section 10 should just be the same as the Sixth Amendment and the U.S. constitutional case law that has already addressed this should apply. If you're asking me personally, to me, I think face-to-face, me and you sitting here talking is no different than if we were on a Zoom call. I mean, to me. So you could construe it that way, that meets the face-to-face requirement, that because again, Mr. Zajac was sworn in, the jury could see him, he could see them. But the main thing is that they could see him, they could hear his voice, and defense counsel had the opportunity to cross-examine him and did. I'm not sure what more I mean, that's essentially the same as what happened if he was physically in the courtroom.
What about the argument that, Mr. Osliger, you look a lot more frightening to me physically in person than you do on Zoom? What about that argument?
Well, I'm not sure that anybody looks particularly frightening in a courtroom outside of the judge. But
realistically, though, if somebody's accused of raping the witness, face to face in person when somebody's 20 feet away, much more intimidating than seeing them on TV.
Yeah, and I think that was I recall the Maryland v. Craig facts. I think had something to do with that. I mean, that's a different fact pattern. But I think we do allow for that, like with child witnesses to testify by closed circuit and so on. So, yeah, but certainly for purposes of this case, I don't think that's an issue. I don't think it was a matter of anybody being intimidated or what have you. All of the protections of the Sixth Amendment were met. I mean, he was, like I said, he was essentially there. He was on a TV screen, but everybody could see him and hear him. He was sworn in, and the defense was able to cross-examine him. And that's really the big piece about, to me, what the Sixth Amendment really is getting at is the ability to cross-examine. Again, it was designed to protect against prosecutors walking into the courtroom with a stack of affidavits or with a whole bunch of hearsay statements that the defendant did it, and there's no chance to question the people who wrote the affidavits or these out-of-court statements. That's what the Sixth Amendment was really getting at, and that's protected here. And seeing that there are no further questions, I would simply ask that you affirm the district court. Thank you very much.
Perkins, you're reserved 2 minutes.
Thank you, Your Honor. I think I would first address a point mentioned in both the Craig and Coy opinions, which is the subtle effects of the right to confront witnesses face to face, and why that plays into the harmlessness analysis that is a weighty burden upon the state. And that's because there are a lot of factors that go into the value and the effects of face-to-face confrontation that are talked about in those opinions. The reality that a witness may simply have different testimony when actually confronted by the accused and the person that they are talking about. That is an inherent portion of this that we just will never know what Mr. Zaitchik's testimony would be like. And I think one of the big factors in here and things to point out and is discussed in those opinions is the role of identification of a person. Mr. Zaitchik testified that he had never seen Miss Younger before. We will never know, based on the record or what we can say about this case, whether that would have been the same had he been in the room and actually seen Miss Younger's face.
That matter. I
And-
mean, the whole story, I mean, even if he had seen her before, wasn't the point of his testimony that I never asked anybody to kill anybody? That's ridiculous.
I don't think we can. That is just an example of how face-to-face confrontation works, but I don't think we can delve into the would have been the same, wouldn't have been the same. I think the harmlessness analysis comes down to, can the state show that this that the error did not contribute to the jury's ultimate verdict, and the state cannot do that in this case. The state saw the defense presentation of testimony. The state determined that 2 witnesses were necessary to respond to that. There's the Fred Viney and there's the Frank Zaitchik, and the state's saying that, well, the credibility question might have come down to just the Fred Viney's testimony, and the jury, you could hypothetically say that Frank Zaitchik didn't matter, but we can't do that. These are both going to credibility. They're going to the credibility of the defense presentation and Miss Younger's testimony, and the state can't excise one piece of their credibility weight there. This case came down to credibility. And at both the district court and in its briefing, the state proposed treating the COVID-19 pandemic as a catch-all justification to ignore the express protections of our Constitution. But our state and federal constitutions persisted unchanged through the pandemic. And I ask this court to continue that persistence and to find that meeting witnesses face-to-face still means face-to-face. And that the state violated that right in this case, and as such, reversed Miss Younger's convictions.
Thank you. Thank you to both counsel for your arguments today. The court will take this appeal under advisement.